consolidate the law and to rationalise it.
The Honourable Leanne Dalzell.
Mr Speaker, the history of this bill has been well traversed by various members who have contributed to it. It started with a Law Commission report. It was followed up with a bill that was introduced that unfortunately wasn't dealt with before the 2008 election. It was discharged, and then a new bill was introduced, and that is the bill before us now. It was referred to a select committee. I wasn't on that select committee at the time. I'm on that select committee now. But I do want to acknowledge the elevation of the then chair of that committee to his new position as Minister of Courts. I think it's a well-deserved appointment, and I know from speaking to colleagues who were on the Justice and Electoral Select Committee in the last term that they too feel that it was a really well-deserved appointment because of the role that he played to facilitate engagement of all parties around that table and to try and get bills back to the House that were in a better shape than the bills as introduced. And I think this bill is a case in point. It is definitely a better bill than the bill that was introduced. However, there are still a few outstanding issues that we do want to raise, and they have been very ably raised by my colleague, our Shadow Attorney General, Charles Chauvel. Mr Speaker, the one good thing about the role that Chester Borrows has played, and now in his new position as Minister of Courts, is that he, like the new Minister of Justice, has shown willing to engage in a very meaningful way, even after legislation is back in the House, and also when dealing with issues relating to his portfolio as they impact on constituency MPs. And I say meaningful because the Minister's response to Charles Chauvel's approach in the short time that she has been Minister and he has been the opposition or the Shadow Attorney General contrasts with that of the former Minister, who actually took an entire year to respond to the letter that the former Shadow Attorney General wrote to him, I believe in 2010. And in fact, to find that to hear that the reply was not received by our former Shadow Attorney General until after the 2011 general election is actually, I believe, quite a travesty of process. And I think it's not something that should be encouraged in this Parliament, to have ministerial correspondence outstanding for such a significant period of time, especially when it deals with such a fundamental issue. And I want to repeat something that my colleague Charles Chauvel said, and that is that legislation like this cannot afford to go through Parliament by a mere 1 or 2 votes. It really does require substantial support in the House for it to have meaning. It is an important piece of legislation. I don't say that for all pieces of legislation. I think search and surveillance, when we're dealing with fundamental human rights, then I think it is important that we ensure that substantial agreement is able to be accorded throughout Parliament. And I don't think that there is much between us on this particular piece of legislation. And I just want to comment on some of the issues that were raised by the member Dennis O'Rourke for the New Zealand First Party, because a lot of what he said relates to matters that are not actually covered in the bill. It is relevant to the bill because the absence of any amendments to the Serious Fraud Office legislation is certainly relevant to the implications of an approach that we were adopting, and our former Attorney General, former Attorney General talked about when we were in government how that was going to occur with the Serious Fraud Office function merging with the functions of the New Zealand Police, and therefore making sense that in fact the Serious Fraud Office provisions stand as they were without being amended, and allow for the police provisions to match an amended set of provisions for the police once that merger had occurred. And so that's why the legislation, as originally introduced by us, didn't include the Serious Fraud Office, and that's why there were some tighter restrictions around the provisions relating to police powers to obtain examination orders. And I think that the Select Committee's got it right for the police, but the fact that it hasn't got it right for the Serious Fraud Office is actually a feature of the legislation, and the fact that without the unanimous agreement of this House, we really can't address these concerns in the Committee of the Whole House. We would have to have an instruction to the Committee of the Whole House that an amendment outside the scope of the bill would have to be agreed. Now, an amendment outside the scope of the bill at this late stage in the piece, I actually don't think that that would be a good process. And the reason I don't think it would be a good process is that we actually haven't heard specific evidence at the Select Committee on that particular issue. So perhaps if I could just simply restate again the suggestion that's come from our two members who have spoken previously on the bill, that perhaps this is an issue that the Minister responsible for the Serious Fraud Office could take on board. We acknowledge that the Minister of Justice has reported to us that what did she say? She said that the Serious Fraud Office will be requested to provide in its annual report to Parliament the number of examination orders made in the period covered by the report and the number of persons charged in criminal proceedings where the collection of evidential material relevant to those proceedings was significantly assisted by an examination conducted under an examination order in the period covered by the report, which are good measures. But I think if the Minister could take on board perhaps the need to go back and reflect on whether this is an area where there could be some further improvement, and I think you've heard indicated on this side of the House that we certainly would be willing, and I think other parties would be willing too, to facilitate the passage of legislation actually bringing the powers of the Serious Fraud Office into the same context or same arrangements as provided for police in the Search and Surveillance Bill. I just want to also comment on the fact that the Serious Fraud Office's view on why they shouldn't be covered by this bill when it was raised with the Minister Simon Power, I think I'd like to put that on the record because I'm a little bit concerned that their view is a little bit self-serving. And so this is a quote from the letter of the 25th of November, which was received on the 28th of November and signed out by the then Minister of Justice, the Honourable Simon Power, who was the Minister of Justice when it was sent but not when it was received. It says this: the Serious Fraud Office's view is that their powers were enacted in the Serious Fraud Office Act with agreement by both sides of the House 20 years ago and have operated with relatively little controversy since. Accordingly, the SFO does not consider that an ad hoc change to one very specific provision in its Act is desirable and could potentially have an adverse impact on the effectiveness of its wider operations. Coming at a time when the SFO is seeking to enhance its responsiveness to serious financial crime, the Minister responsible for the SFO and the Director of the SFO consider any proposal to change its powers would be more appropriately achieved as part of a more comprehensive policy development process in relation to the SFO itself. Mr. Speaker, I think that does perhaps give us a way forward, and I do encourage the now Minister responsible for the SFO to take on board the recommendation, certainly from many members of this House, that to have the extension of or to have some limits placed on the powers of the SFO. I do think that to rely on the fact that it was enacted 20 years ago, when our thinking around some of the human rights issues may not have been as advanced as they are today, And given that they've operated with relatively little controversy since, I think they've forgot to notice themselves the controversy surrounding their own use of their powers with the National Business Review, as my colleague has pointed out. The last thing I just want to mention very quickly is that this does make an important point in relation to the press freedom. And we rely on the media being able to report on things that need to be brought to the public's attention. I know in the financial markets area this is absolutely vital, and I wouldn't want to think that people wouldn't bring things to the media's attention.
Sorry to interrupt you, honourable member. Her time has expired. I call Dr. Jackie Blue.